Ladies and gentlemen, good afternoon. My name is Adarna Ott. I'm a lawyer in the corporate division of the official receiver. I'm more than glad to have you here in this rather difficult time of the day. Our topic will be the administration of a Chapter 11 case. Our first guest is the Honorable Judge Drain of the Bankruptcy Court for the Southern District of New York, a fellow of the American College of Bankruptcy, a member of the American Bankruptcy Institute, and a professor at St. John University School of Law. He has presided the bankruptcy cases of Star Tribune, Refco, Cornerstone, etc. He will speak on the court's role in overseeing a case. Thank you.
Good afternoon. I must say I've never been preceded by a performance artist, or by Albert Einstein for that matter, but it's a pleasure to have been preceded by them and also to be here, and I want to thank our hosts for being such great hosts. My topic this afternoon is the role of the bankruptcy court in administering a bankruptcy case, which is appropriate since I've been a judge since 2002 in the bankruptcy court for the Southern District of New York. We have, as I'm sure most of you know, special bankruptcy courts to administer bankruptcy cases. And I think that's an important point, which is that the bankruptcy judge administers the entire case. So if a company files, if, for example, Lehman Brothers files for bankruptcy, one judge is assigned to that overall case, and he or she will decide all of the issues within that case, and there are many issues that come up from start to finish. The primary model for U.S. bankruptcy cases is the adversarial model, where the parties, if they have a dispute, litigate the respective sides of that dispute in front of the judge. The judge makes independent findings of fact and conclusions of law based on hearing the evidence in that dispute. There's no expert appointed unless the judge seeks the appointment of an expert, which is very, very rare. And as you've heard from Professor McKenzie and others, the exception in bankruptcy cases is the appointment of an independent trustee. Generally, the debtor continues in control of the case. So that was a conscious decision by Congress to have the general court model for bankruptcy cases, which again is an adversarial model. Information, to the extent that it's not shared, comes out through the litigation process, and the court decides the issue. And there are many issues that the court decides throughout the Chapter 11 case, starting with the initial part of the case, which involves debtor in possession financing, to issues affecting the debtor's business, whether the debtor should sell his particular asset, reject a particular contract, perhaps buy a particular asset, and leading up to the end game of the case, which is the either the approval after the court's considered it of a disclosure statement for a plan, and then approval of a plan, and or a sale process pursuant to which substantially all of the assets would be sold. The original model for bankruptcy court's administration of cases then was one where the bankruptcy judge was fairly remote from the day-to-day activity in the case. The judge was there only to decide specific issues if the parties weren't able to reach consensus. Again, this was a conscious decision by Congress to get away from the model that existed in large respect before the 1978 Bankruptcy Code was enacted, where judges were much more involved in the day-to-day activities, not of the litigated aspects of the case, but the case generally, and also involved interacting with trustees to run the, who would be running the Chapter 10 case. I think that Congress was concerned that that practice had put judges in an awkward position where they were not necessarily always independent fact finders. They had extra information from knowing more about the case, and there was some concern also about cronyism with the appointment of trustees and the role of the judge in the case. Clearly, the model for Chapter 11 cases is much more all-inclusive. The Bankruptcy Code has a very broad definition of a party in interest who's entitled to be heard. It's basically anyone with a financial stake in the business. The Bankruptcy Code has a very far-reaching discovery provision that enables any party in interest to take discovery on pretty slim showings. The case law actually acknowledges that you can go on a fishing expedition to get information about the debtor and the debtor's business. And the process of confirming a plan also contemplates a disclosure statement that is on notice to everyone that the court needs to review. As Jay Goffman mentioned in his talk, that model worked pretty well in the 80s, but led to a fair amount of litigation and delay. And with the growing sophistication of the practice and the acceptance of, among other things, the sort of best practice of a debtor sharing information with the other constituencies in the case, which wasn't always the case in the early stages of the enactment of the Bankruptcy Code. The role of the court has changed somewhat. And I want to speak about 2 or 3 of those changes. And it's an evolving role. I could speak for myself. I can also speak for having observed judges when I was a practitioner, but also talking with my colleagues. In addition to deciding specific issues in cases, I think over the last several years, bankruptcy judges, while being careful to preserve transparency and not to have ex parte communications and not to even give the impression of favoring one side over another, have become more involved in the running of the case generally than simply deciding contested issues. Partly this is because the parties in the case have asked the judge to become more involved and have indicated, both in the cases themselves and in meetings like this that we would have in the US, that they welcome a little bit more participation by the court beyond just deciding discrete legal issues based on hearing the evidence. So what do I mean by that? I think, let me give you 3 or 4 different examples. First of all, there are clear steps that any judge can take short of deciding a litigated issue. And this isn't anything new or particularly different than I imagine your judges here do. So, for example, if it appears in the early stage of a litigation over whether the debtor is performing properly, that there is a legitimate issue about information sharing, I will have no problem saying to a debtor's representative, you have to share this information. It's not really been brought up in a contested setting where there's a motion to share the information. Instead, we would be having a conference because we'd be having, monthly hearings in the case. And it's an opportunity, because you have monthly hearings in the case, for people to raise problems. And since everyone's there, there's a fairly easy way to get to the answer short of having a whole contested litigated hearing. So if, contrary to the best practices, a debtor, and it's often a debtor that's not as well represented as some of the people here would, but maybe not as experienced a person representing them, is hiding the ball or appears to be hiding the ball in terms of sharing information. Just in the context of a case conference, I would say to that debtor's lawyer, this isn't right. It doesn't sound right. Now, maybe you have a reason for it. Do you want to explain that reason to me? If they can't, then the message is there that if they don't start sharing the information, the next time they come back, there may well be a ruling by me when someone has actually made the motion, but hopefully that remark will have short-circuited a full-blown litigation over the issue. Secondly, and again, this comes up often in case conferences and with the impetus of the professionals who are running the case, both for the creditors and the debtor, the court may adopt procedures for dealing with specific types of issues. For example, some cases have a large number of personal injury claims because that's just the nature of their business. I have presided over a couple of supermarket cases. Well, people are always falling down in supermarkets. So the debtor's lawyers, being thoughtful and trying to cut down on expense, in a case conference said, "Judge, would you be amenable to hearing a motion on procedures for how to deal with all of these personal injury claims, slip and fall claims?" And I said, yes, if it makes sense, put it on notice to everyone, including the claimants themselves. And so they proposed a series of procedures that required a special type of claim form that would lay out the type of personal injury that was geared to negotiation followed by non-binding mediation from a mediator that generally does these types of claims. And so where conceivably there would have been, 1,500, 2,000 individual litigated cases over those claims, there really haven't been any in this case because that procedure worked. So that's another way that the court gets involved short of deciding a discrete issue in the case. In addition, and this is becoming much more common in large Chapter 11 cases, it may appear, again, because someone in the case raises the issue, or it may appear to the judge himself or herself, that the parties would benefit from having an independent mediator meet with them and discuss the issues surrounding the formulation of a plan. And as I said, this has become much more common over the last 2 or 3 years in Chapter 11 cases, and I think generally has been very productive. They're difficult mediations because they often involve scores of parties and often scores of issues. We often are asked if we would appoint another judge as a mediator, and solely as a mediator in non-binding mediation to facilitate a settlement. And we will do that for each other, which also has the benefit of being free. But it's again a way to reduce the time and expense of the Chapter 11 case, which otherwise is set up as a multi-party litigation. We have a code that in many respects encourages negotiation in the first place, but also gives, unfortunately, to some extent, parties leverage to delay case by threatening a litigation. What do I mean by that? Many of the key issues in a bankruptcy case involve valuation, and people will be talking about valuation today and tomorrow. The judge is responsible ultimately for, if the issue is fully litigated, for determining the valuation. Bankruptcy judges are generally not independently experts at valuing companies or collateral. We are experts at listening to evidence about that. We are encouraged to reach a determination of value by the fact that really no one can peg the value of a company. That's why we have stock markets, and why some people are losers and some people are winners in public markets. But for that same reason, which is the uncertainty of evaluation, ultimately the code, by having the bankruptcy judge be the final person to decide value, whether it's for adequate protection purposes of collateral or for the ultimate value of a company, encourages settlement rather than have someone like me make that determination after a very lengthy and expensive process. The parties have their own experts. They have lawyers who can negotiate these issues, and hopefully business people will do the right thing and reach a consensus on that issue, which is usually the issue that's driving the entire case. There are times, though, when people won't do that because they perceive that there's negotiating leverage in just forcing the determination and forcing the cost, and appointing a mediator to basically knock heads over that issue is one way to try to avoid that type of wasteful litigation. Someone asked earlier today, why wouldn't the parties just rely on an independent trustee and his or her own determination of value? But my immediate response is they just wouldn't, because it wasn't that person's money. The parties in cases in the U.S. Are much more attuned to hiring their own experts and negotiating it out with the other side than accepting someone who doesn't have an economic stake in the outcome, even if that person is completely objective. They basically say that's the judge's role at the end of the day, and that's the way the code is established. But on the other hand, we recognize that process can be wasteful and therefore push the parties pretty hard. And I think this is in keeping with the code's structure to settle those issues. I think it's extremely important to have the business people present at those types of negotiations to get them to accept that it is their money at stake and it's a waste of their money to have the matter litigated. Particularly in smaller cases, if I see one side taking what appears to be an uneconomic view, and sometimes it's simply because of laziness, or sometimes it's just because they don't want to be involved in court, so they just turn it over to their lawyer, who doesn't really have a direction. I will insist that at the next hearing, a business person be present to hear the evidence, to hear what I'm hearing, and that usually leads to a settlement. So this is a role that I think Congress didn't necessarily envision for a bankruptcy judge in 1978, but it's clearly developed in terms of putting your hand on the issues short of deciding them based on hearing the evidence and weighing the law. There's one other area which, by its very nature, bankruptcy judges are doing more than just deciding the facts and the law. And this comes up in an area that I think is very important to this group also, which is the case of transnational bankruptcies. By its very nature, if I'm presiding over a bankruptcy of a business in New York that at the same time is in a foreign bankruptcy proceeding or insolvency proceeding, I cannot decide what's happening in the foreign bankruptcy proceeding, and vice versa. The foreign judge can't decide what's happening in my case. So that requires the court to reach out in various ways, short of deciding issues,